𝗟𝗏𝘃 Law is one of the top immigration law firms in the USA. 100 officers, including law clerks and case managers, work in different departments under the supervision of attorney 𝗟𝗏𝘃 and other associate attorneys in the United States. The success rate of 𝗟𝗏𝘃 Law is over 99% in fulfilling the dream of people from other parts of the world. Family-based, employment-based, asylum, and green card-related services are available under one umbrella in 𝗟𝗏𝘃 Law. In addition, this law firm is one of the best in the United States for obtaining services related to NIW, writ of mandamus, and student visas. The headquarters of 𝗟𝗏𝘃 Law is in Washington, D.C. metropolitan area. We have a branch office in Atlanta, Georgia, to reach the services easily of 𝗟𝗏𝘃 Law to everyone living in Georgia. Besides, we have a country office in Bangladesh. The contact address and phone number are shown for any immigration-related services. You can also email info@rawjlaw.com. 𝗟𝗏𝘃 Law is your safe address for assistance and advice regarding immigration to America.
Hello everyone. I'm happy to welcome you all to the weekly Sunday live session of Attorney Raju Mahajan and Associates. We talk about various immigration topics in our live sessions. Then we have a very productive question and answer session where we always try to answer your questions regarding US immigration policies. Let's welcome our principal attorney, Mr. Raju Mahajan, who is the founder of Attorney Raju Mahajan and Associates.
Thank you, 𝗟𝗏𝘃, for introduction. Thank you, everybody who are watching this show right now or will watch it later in our Facebook, YouTube, or in our LinkedIn channel. I welcome all of you in this show.
Thank you, Mr. Mahajan. We are thrilled to have you on board. Today, we are going to discuss about the H-1B visa in continuation to one of our previous lives on H-1B. The H-1B visa allows US employers to hire highly qualified workers for specialty jobs. I am affirmative that many people may have questions regarding this visa. Please save it for later. First, let's hear Mr. Mahajan's insights about the H-1B visa. Mr. Mahajan.
Thank you, 𝗟𝗏𝘃. Let me share my screen. Do you see my screen?
Yes.
Do you see my screen?
Yes.
It says, what is AC21?
Yes.
Okay, thank you, 𝗟𝗏𝘃. All right, thank you, everybody. I am sharing my screen. That's why I just made sure that you all are watching my slides. So many of you already know that a couple weeks ago, we discussed about H-1B. And many of you already know that H-1B visa will grant you 6 years work authorization in America for you, and your spouse will be in H-4 categories. However, in many times, in many situations, you may need to extend your application beyond, you may need to extend your H-1B status beyond 6 years. And to address that issue, American Congress, they introduced and passed a bill back in 2000, in the year of 2000, and it is called AC21. So the AC21 is the short form. The longer name of the law is American Competitiveness in the 21st Century Act. So that act was really, really helpful for H-1B visa holders. So today we will discuss how you can get benefit under H-1B visa beyond your 6-year status to work in America. So AC21 law, it provided 2 significant provisions to skilled immigration workers. One is it allowed H-1B visa workers to change jobs before even obtaining their green cards. Previous to this, the workers were forced to work with an employer for 6 years before they got their green card. So for this first one, we already discussed in our previous session that while you are in H-1B, you can definitely transfer your H-1B from one employer to another one. You can definitely apply for concurrent H-1B. Under concurrent H-1B, you can work under 2 different corporations at the same time. One would be your primary H-1B, one would be your concurrent H-1B. You can also apply by sponsor yourself under H-1B application. So there are many significant benefits of H-1B, and the first part that we are going to we mentioned here, we already discussed a few topics, so I'm not going to go that detail about the first one, but the second one is basically our today's topic. The second one is AC21 were also allowed to extend their status beyond their 6 years. So today we will basically focus on how a H-1B visa holder can work beyond their six-year limit. So a lot of time, people, spend 6 years in H-1B but still did not get green card because of some reason. So this is very helpful for them. Let's go to the second slide. Next slide. So what are the AC-21 visa extension requirements? So a lot of time, it's not just you can just go ahead and apply for AC-21 extension. You must meet certain criteria. So there's two kind of extension. One is a 1-year extension. Another one is 3 years extension. Of course, 3 years extension is better than 1-year extension, but depending on your situation, you may be qualified for either 1-year extension or 3-year extension. So let's first talk about 1-year extension. You may extend your visa duration annually on a 1-year incremental basis as long as you initiate the extension process at least 365 days before your 6 years duration date, expiration date. So all it means is, let's say you are in your second 3 years of H-1B visa, and you did not apply for I-140 or have no approved I-140 yet. So you can extend for 1 more year, and each year you can apply for one more year. So it's like a 1-year incremental basis. So every year you can extend 1 more year and you can stay in H-1B status. However, you have to apply at least 365 days before your 6-year expiration date. So this is very significant. A lot of time, clients come to us and say, hey, I want to extend my H-1B application, and I have, like, let's say 1 month, 2 months, 3 months, 4 months. In that situation, you cannot extend for 1-year extension because you do not have 365 days left over. You must have 365 days
excuse me,
left.
Mr. Mahajan.
Yes.
The slides are not visible.
Oh, slides are not visible. Okay. Interesting. Can you see that now or not?
No, it's the previous one.
Okay. All right. So let me go to the traditional way. Let me upload. Oh, sorry. Let me upload here. Presentation, slides. Sorry. My computer. Sorry about this delay. I'm trying to upload my presentation here. Yeah. Samir, can you please add the my presentation to the screen? Yes. Yeah. Please stay there. Yeah. So thank you, Samir. So this is the slide I was discussing on. So for 1-year extension, you must apply before 365 days of your 6th year expiration date. And for the second category, which is 3 years extension, if your priority date is not current, but your I-140 has already been approved, you are eligible for applying for a 3-year extension. So this is very significant. That's why, recently a lot of people, they are getting NIW approved, but NIW means their I-140 is approved. However, they do not have, they cannot apply for I-485 because their priority date is not present in the visa bulletin. If you are in H-1B visa and if you have an approved I-140, but you cannot apply for I-485 because of priority date, you can apply for H-1B extension for 3 years because you already have a I-140 approved. That's why approved I-140 is really, really helpful. And I request my clients, like, if you can apply for NIW, please go ahead, do that. That will definitely help you. So the bottom line is, to apply for a 3 years extension, you must have a I-140 approved. Then you are eligible to apply for I-140. Let's go to the second slide. Okay, so the other critical requirements for an H-1B visa extension are, so this is for the 3-year extension. Right now I'm talking about the 3-year extension. So the change in employment should occur within the same or similar occupational classification. So if you are still employed by the same company, you do not need to worry about that part, because you applied for H1B under the same company, and you applied for I-140 under the same company, so you're good. However, a lot of time people change their employment from company A to company B. If you change your employment from company A to company B, the change in employment should occur within the same or similar occupation. This same or similar occupation is this term, same or similar, is very significant. I will discuss that in my later slides, so please pay attention. The next criteria is your I-140 has been approved or can be approved by the time your I-485 is approved. So this is kind of like a future tense we're talking about. A lot of time we do like our informed guess, when your I-485 would be approved. So even though your I-140 has not been approved yet, but your I-485 may have been approved in that time, then we can apply for 3-year extension. I know this is kind of like a very complex situation. It's very hard to tell that without giving any example. So this is just for information purpose. So just listen to this. If you do not understand, you have to please contact me, and I will explain it for your situation. The third requirement is the form I-140 has been pending for no less than 180 days. That means 6 months. If you do not have a I-140 approved status, however, you applied for I-140 and it has been pending more than 180 days, then you can also apply for 3-year extension. So these are the 3 critical requirements for H-1B extension for 3 years. Let's go to the next slide. So now the question is, what are the same or similar job determination? There are many requirements for H-1B extension, especially for 3 years, and one of those are like same or similar, and there is no fixed definition for same or similar, but here are 3 situations, 3 requirements that I mentioned here. You have to make sure that your job description, skill requirement, and experience details contained in the I-140 are compared to the new job being offered. They have to be almost the same. So the previous job and the new job, in both scenario, the job description, skill requirement, and experience details must be same or similar. The next one is the DOT code or SOC code mentioned on the labor certification will be used to determine the similar occupational classification of both jobs. So the SOC code that we mentioned in I-140 application, many of you who applied for NIW or going to apply, you will see in page 4 of I-140 application, there is a question for SOC code, and we provide a SOC code. This SOC code is very significant. So when you change your employment from one company to another company, one job to another job, you have to make sure the SOC code is either same or similar. Then the last one is the salary package should be similar to the previous one. It cannot be like significantly different from each one. So let's say in your previous job you got like a $100,000 annual salary. Now you're getting like $60,000 annual salary. So it's not same or similar. So the salary package has to be very same or similar. So there should be there should not be any drastic change in the CTC or stock option either. So those are like the requirement for to be same or similar. Now the question is, what about the dependents? Many times H-1B holders, they have dependents under H-4. So when they apply for after their 6th year of H-1B, when they apply for a 1-year extension or 3-year extension, their dependents also get the extension too. Their extension would be under H-4. However, you have to apply it. It will not be automatically granted just because your application was approved. So when you apply for extension, either 1 year or 3 year beyond your 6th year, you must apply H-4 extension 2 and try your best to apply similarly at the same time. So both of those will be approved at the same time. So I think that was our presentation on H-1B for the second part. And thank you very much for watching. Now we'll go for a regular question answer.
Thank you, Mr. Mahajan. It was a very insightful session for me and also for our audiences. You have managed to cover some really important areas of H-1B visa in this short period of time. Now, let's move on to our question association. Our very first question is from Skillshare. Is it possible to apply H-1B without informing the employer?
No, it is not possible, because you are not applying for H-1B. You are not applying for H-1B extension. You are not applying for anything. You are the beneficiary. It is the company who are going to apply. They need to sign. So if you sign in your employer's place, that's a fraud. Please do not do that. Just remember that H-1B visa is not, you're not going to apply for that. Your employer is applying for that, and make sure that they are well informed. They sign the form and they provide all the information. Please do not apply by yourself in the name of your company.
Okay, he asked one more question that after getting H-1B visa, can I apply for green card?
Yes, you can apply for green card anytime. It doesn't matter whether you're in H-1B or not. But yes, the short answer to your question, you can apply for green card after you're in H-1B visa.
Another question came in, that is, how long does it take to obtain the H-1B status from the registration to the approval of I-129?
So it depends. There is also premium processing. So if you do premium, so let's say the first step is the lottery. If you win the lottery, then we'll go to the second step, which is I-129. And when you apply for I-129, there is a premium process to get it expedited. However, no matter you take the regular process or premium process, you cannot start this job under this H-1B until October 1 of that year. So let's say we are in 2023. A lot of people already applied for lottery. Let's say you win the lottery at the end of this month. Then in the beginning of April, you apply I-129 under premium processing and you get it approved at the end of April. You still cannot start this job until October 1 of 2023. That's why a lot of people, they think, well, why I'm going to spend extra money for premium processing if I cannot start the job. On the other hand, a lot of people, they want peace of mind. So they say, it's okay, even though I'm not going to start this job before October 1, I'm going to apply for premium processing just to make sure that my H-1B is approved and I have peace of mind. So is the question for you whether you're going to apply for premium processing or not. But yes, you can. I-129 will probably approve within 1 month or two.
Okay. The next question is from Princess Lizzie. She wants to know that who applies for H-1B extension visa, you or your company?
Your company. Any kind of H-1B application is by the company.
The next question is there any wage requirement for H-1B status?
Yes, there is a wage requirement, but this is not as strict as PERM wage requirement. Usually this is more flexible than PERM, but yes, there is a wage requirement.
The next question is, when should I apply for the H-1B transfer?
You can apply for H-1B transfer anytime. However, if you try to transfer your H-1B after you being laid off or you left the job, then you have 60 days to apply for H-1B transfer. So in regular time, you can apply for H-1B transfer anytime. But if you are laid off or you left job, you have only 60 days to apply for H-1B transfer.
We have a question from Mr. 𝗟𝗶𝘆. He wants to know that what are the chances of winning the lottery if you belong to the master's quota?
Well, lottery is lottery. If I say you have 99% chance and let's say you did not win, those 1% is enough for not being selected. So lottery is always lottery, and US government really makes like a fair lottery. There is no nepotism or any kind of like corruption there. So it's hard to say what is the chances of approval. It's just luck.
Thank you, Mr. Mahajan. I don't see that any more questions coming in. I think it was a very insightful session and all of the audiences are satisfied.
Thank you very much, everybody, for watching this show. And I'm sorry that there's like a noise in our background. Next week, we'll try our best to make sure like a smooth presentation. And it was disrupted by the technology also, but next week we'll do it better. Thank you very much for watching this show.
Thank you, everyone. We try to reply to all the emails within 72 hours. You can ask any questions to info@rajulaw.com. You can also contact us at 833-7258529. Thank you, everyone, for your time. We'll be back again next week. Till then, stay connected. Thank you.
Raju Law is one of the top immigration law firms in the USA. 100 officers, including law clerks and case managers, work in different departments under the supervision of attorney Raju Mahajan and other associate attorneys in the United States. The success rate of Raju Law is over 99% in fulfilling the dream of people from other parts of the world. Family-based, employment-based, asylum, and green card-related services are available under one umbrella in Raju Law. In addition, this law firm is one of the best in the United States for obtaining services related to NIW, writ of mandamus, and student visas. The headquarters of Raju Law is in Washington, D.C. metropolitan area. We have a branch office in Atlanta, Georgia, to reach the services easily of Raju Law to everyone living in Georgia. Besides, we have a country office in Bangladesh. The contact address and phone number are shown for any immigration-related services. You can also email info@rajulaw.com. Raju Law is your safe address for assistance and advice regarding immigration to America.